Hey guys, this is Roxann Smithers with Smithers and Ume-Nwagbo, your trusted 360 general counsel, and this is a note from my Legalpad. So when a client comes to me and we're talking about how they can enforce their rights in a contract, or they're looking to respond to a litigation claim that's being asserted against them, once we kind of walk through the process and we talk about how long it may take to be involved in a litigation dispute or an arbitration or a mediation, one of the first questions that clients ask me is, well, can I get my fees back from the other side if I'm successful? And unfortunately, in many cases, I have to tell them that the answer is no. So we're going to talk a little bit today about why my answer might be no and what we can do to turn that answer into a yes. So, an unfortunate side effect of our legal system is that it can be a long process. It can, in many cases, be a complicated process. And it can often require that for the best results for an individual, they must have legal representation. And legal representation certainly can cost a premium and can range in its cost. But clients are always wanting to find out if they're in a legal dispute that either they initiate or that they're responding to, whether or not they will be able to get their legal fees back from the other side if they're successful. So there are a couple different factors that play into whether my answer to that question is going to be yes, no, probably not for a client. And the first thing that you have to understand about the American system, as opposed to, for example, maybe the English or British system, is that we don't have a winner sort of take-all system. If you are the initiator of a legal dispute, or if you're the respondent to a legal dispute, whether or not you are successful in pursuing a claim or in defending yourself against a claim does not automatically give you a right to recoup the legal costs that you've incurred to hire an attorney and to respond to that claim. In our American system, each party is generally responsible for their own legal fees. Whether you're the initiator or whether you're simply responding, whether you're the successful party or whether you're the losing party in litigation. And so the best way for me to be able to tell a client yes when they ask me if they can get their legal fees back is if they have specifically put into their contractual relationship and their contractual documents with the other party a provision that gives the successful party in a dispute a right to recoup their legal fees and costs. This can be titled just an attorney fees provision. It can be titled a prevailing party provision. It can be titled a attorney fee shifting provision. But in essence, what it may say is if either party, or one party in particular, depending on who's drafting and controlling the contract, if a party has to take legal action of any sort to enforce their rights in the agreement against the other party, that they will be able to include as part of kind of their damages or what they recover, whatever attorney's fees, collection costs, court costs that they have had to spend in order to enforce the contract. In other words, we'll say whichever party prevails in a dispute, the expense that they've incurred in order to prevail in that dispute, they will be able to recoup that expense. That is the most powerful, the most assured way to make sure that you have a right to recoup your attorney's fees and costs if you're in a legal dispute. Now, in those situations where you're not necessarily in a contractual relationship, say it's a personal injury claim, some sort of tort claim, a conversion claim, something where maybe the parties did not have a prior existing legal relationship. There's been some sort of wrong, and now the parties are in a legal dispute. In those instances, unless there's a specific law or statute um, under which the person is bringing the claim or bringing the dispute. Unless that statute specifically says that the party that succeeds in bringing a claim under this law or under this statute, that party can get their fees back, again, the party is not able to get their fees back. So some examples of that, specifically if you are doing work with government entities and prompt pay provisions that require general contractors or subcontractors on certain types of projects to pay their suppliers and their subcontractors in a certain amount of time, and they fail to do so. Those statutes often say that the party can get their fees back if they have to bring a legal claim for non-payment. That's one example. And there's some other statutes where if there is a civil remedy, there's a right to get your fees back. The last situation is very rare, but in an instance where you can prove that, if the successful party can prove that the losing side had no valid basis to resist the claim, to not pay the claim, to not respond and resolve the issue, or that they have brought a legal claim simply for the purposes of abusing the other party, then you can attempt to request to get your fees reimbursed for the expense that you've incurred to either defend a claim or to prosecute a claim. And that's generally called abusive litigation, or someone is being what's termed stubbornly litigious. If they have no good faith basis for either their claim or their defenses, that's another opportunity to ask the court to reimburse you for the attorney's fees and costs that you've incurred to pursue the claim. That happens in very rare instances, and there has to be very strong facts to support the idea that the person is acting in total bad faith and that there's no basis for the position that they've taken in the litigation. So those are the ways in which it's evaluated whether or not you'll be able to pursue your legal fees. The strongest position is if you have a contractual provision in your written agreements. The second is if you are bringing an action under a statute that allows you to recoup your attorney's fees or costs. And the third is if you can show that the other side has acted abusively or stubbornly and has required you to incur these legal costs without any reasonable expectation that their position would be successful. It's important to understand what rights or limits you have on your ability to recoup your legal costs when thinking about whether or not to initiate a legal action, whether or not to fervently defend against a legal action, and in calculating whether or not a resolution or a settlement is actually in the party's best interest. So we always think about sort of the net recovery whenever I'm advising clients with regards to pursuing a claim or resolving a claim once a claim has been initiated. And this has been another note from my Legalpad. And for more information from the attorneys at Smithers and Ume-Nwagbo, you can find us at stulawgroup.com. You can find us on Facebook, LinkedIn, as well as Instagram. Please do subscribe to the channel and like this video, and so you will get more information and more postings of notes from my Legalpad.